I think it's just about right.
This is a test of the judge's microphone. Test 1, 2.
Everybody just needs to stagger the seats a little bit.
I definitely feel it.
Yeah, you're right.
Here,
We could probably,
Joyce, come
we could
on.
This is a test of the witness microphone. Test 1, 2.
Sitting in the back row name.
Go
You
ahead.
need to push the front row name up and the back row name
well,
down.
I think we need to know. How many hours are there?
I should be in the back. Pardon me.
Michelle.
Why do you want to be in the back?
Because I'm not, I guess I'm not, I shouldn't be in the front.
Let's take 2 chairs out, and then we can stack. That way we have more room.
Okay.
Then we'll stack.
Move this one down.
We have been in the back. We had some preliminary matters that had been raised, one of which was for the dismissal of counts 4 and 20. That motion was filed by Judge Alred. There was a response and a supplemental memo filed by Judge Alred. That motion is sustained, and counts 4 and 20 are dismissed. There was a second renewed motion for myself to disqualify. I declined to disqualify, and after I left the room, the members of the commission voted that I should not disqualify, so I will not disqualify. We do have some motions to, well, before that, let's have appearances on behalf of the commission and on behalf of Judge Alred.
Good morning, Your Honor, members of the Commission, Jeff Mando, Louis Kelly, and George Robbie for the Commission.
Thank you. Judge Alred?
Russell D. Alred, Circuit Judge, 26th Judicial Circuit, for myself, with my wife and my son.
Thank you, Judge. We have a motion. We have some motions to quash subpoenas. I believe there was a motion filed by Bill Ball and Amy Ball Bennett. Is counsel for the Bennett's present?
Good morning, Your Honor.
Good morning.
May it please the court, members of the tribunal, I need to advise the court and the tribunal that I'm here in a joint capacity. I am both counsel for Mr. Ball and his daughter insofar as the motions to quash their subpoenas are concerned. I am also subpoenaed as a witness on behalf of the prosecution.
All right.
Mr. Chairman, in light of Commission's ruling on counts 4 and 20, we will no longer need Mr. Melvin to testify as a witness in this proceeding.
All right. You're here on behalf of the Bennetts, or I'm sorry, on behalf of the Balls also.
That's correct.
All right.
Mr. Chairman, I hate to interrupt you, but just out of an abundance of caution, to the extent that these motions are going to involve the discussion of proffered testimony of a witness, we would invoke the rule and ask for the separation of witnesses that are in the courtroom.
All right. Members in the audience, the rule has been invoked. What that means is that anyone who is a potential witness in this matter must remove themselves from the courtroom. They should not have discussions as to what testimony goes on in here with any person who is a witness. So at this time, if anyone is a potential witness, you're going to need to leave the courtroom. Let me ask you,
Listen, the parties want to make a motion.
I'm sorry. They certainly can remain. They certainly can.
You're not excused, my ladies, you're not excused.
Come around.
Which side would you like?
We have reviewed the motion that has been filed. Judge Alred, I'm assuming you have subpoenaed these folks. Do you wish to be heard? I assume you do.
Yes, I do, Mr. Chairman. I will receive the responses to the subpoenas, motions to quash, a relatively quick time period before today's hearing, and I apologize to the committee for not getting permission, rather, to get a response in the record. The simple fact of the matter is that I have subpoenaed Bill Ball for the purpose of him testifying about an event he was involved in, not a counseling event, not spiritual counseling between him and the sheriff or any member of the sheriff's department. It is my desire to examine Mr. Ball in regard to an event that relates to the allegation. I'm trying to think which count it is. It's in regard to the allegation by the sheriff that I had ex parte'd him and forced him to open a drug trafficking case against a Mr. Wallace Smith. It is my intention to show that Mr. Bill Ball is a close personal friend of Mr. Wallace Smith. And Mr. Bill Ball and the sheriff came into my office attempting to ex parte me concerning Mr. Wallace Smith, and I quickly headed them off, did not even address Mr. Ball, addressed the sheriff, and told him to exit my office. It is also my testimony, or rather my attempt to defend myself in regard to that charge, by showing that I was called by the sheriff on a telephone call with a speakerphone, and he again, the sheriff, attempted to have me probate a Mr. Wallace Smith. It is my position that Mr. Bill Ball was a witness to that, a very important witness to my defense, and I have no intentions of questioning him about any type of confidential communication as a counselor. That's what he's being subpoenaed here for today, and I do not believe that falls under the privilege that has been cited here, and I have no idea why we would quash the subpoena until we heard what type of testimony was coming in, and if it was something that was privileged, he could cite his privilege, and you all could rule on that then and see if it was something that was privileged. I think that's my position. In regard to Ms. Balls, if I may, Mr. Chairman, in regard to Ms. Balls, she was subpoenaed. The subpoena was already prepared long before I got the motion to quash, and she was served for the purpose of a comment she made at the hospital in regard to the allegations 1, 2, and 3, wherein it is going to be part of my defense that the reason those allegations flared up, that the sheriff, that the Commonwealth attorney are saying the things they are and giving the testimony they're giving, is because I would not allow $50,000 of donated money from 2 criminal defendants to make their way into the hands of the sheriff's office and the chaplain's court. When that came out, it is my intention to question Ms. Ball about a comment she made at the hospital where she worked to the effect of, Judge Alred is keeping Daddy's money. That's Daddy's money. And that is very relevant to my defense in regard to this case. And that's what I've got them here for. Her testimony will be very brief, very limited intrusion. I'm not getting into any familial issues with her or her father, and that's it. It was not done for retaliation. The subpoena was already prepared. It just so happened that she got served. As you know, I had a lot of subpoenas to serve, and she got served at a late date. That's my response.
I'll hear from the commission. I assume you don't have a whole lot to say, but I'll hear from you and then hear from counsel.
The commission has no position with regard to the motion to quash. We'll reserve, obviously, on relevancy with regard to the proper testimony as detailed by Judge Alred.
All right. Yes, sir.